Hi, David Campanile here, owner of Campanile Law, located in the state of New Jersey. We handle estate planning and probate. Today's topic is going to be about what are the requirements of a valid will. But before we dive into that, if you have any questions pertaining to estate planning or probate and you want to schedule a free strategy session over the phone with me, head on over to njestateattorney.com right now to schedule a day and time that works best for you. So, let's jump right into this. What are the valid requirements of a will in the state of New Jersey? Well, there are things that we look at before the will and things in the will. So before the will, the two things we're looking at are is the person who created the will over the age of 18, and was the person who created the will of competent or sound mind. Now, the levels of competency is very low in the state of New Jersey, actually. You can have an individual who creates a will who may have dementia or may have things, but at the time of signing, they understood what they were reading and what they were signing. So understand that that could be a form of competency. That's why we have witnesses. So, which isn't part of the other requirement. It must be in writing. So a will cannot be oral in the state of New Jersey. It has to be in writing. It has to be signed by the person creating the will. We don't allow for electronic signatures right now in the state of New Jersey. We still need a wet signature on the document. And lastly, it has to be witnessed by at least two other individuals. They cannot be parties to the will, so you cannot be an interested party in the will. A beneficiary, a named executor, receiving anything in the will. And that has to be signed within a reasonable amount of time by the witnesses who saw the individual sign their will. Now, the other thing we do too sometime we'll do is attorneys are notaries in the state of New Jersey, so attorneys will sign off on the will. Or if you need a notary, you can head on over to your bank. Law firms sometimes have notaries should have a notary on staff. You can hit your local UPS store to get the will notarized as well. That's kind of just like the final part of the whole thing. So let's just dive back. I know this is a short video, but let's summarize it quick. Over the age of 18, be competent, in writing, signed by the creator of the will and witnessed by two other individuals. That's really what the requirements of a valid will are. Remember, it can't be oral. We can't go in and say to the court, well, you know, I was told my father or my parents told me, 25 years ago that this is their will, and you speak it. We need it in writing. So, if you found this video informative, please hit that like button. If you know somebody who has questions pertaining to estate planning or probate, send this video out to them. Tell them you were thinking about them. If you would like to discuss this topic or any other topic in estate planning or probate, head on over to njestateattorney.com right now to schedule a free time to speak with me directly. As always, my name is David Campanile. I'm the owner of Campanile Law, located in the state of New Jersey. We handle estate planning and probate.